Good evening, everyone. Thanks for joining me on this Wednesday evening. We're going to give folks just a couple of minutes to join us before we get started. But during the webinar, you guys should have the ability to drop in any questions into the Q&A, and we'll sort of save the questions until the end. I'll take a look at them and do my best to answer them as we go through. But sit tight for about another 2 minutes and we'll get underway. All right. For those of you who just joined, just a quick note here as we launch the webinar and we go through this. I'm planning on it taking hopefully not more than 15-20 minutes. We're going to keep it short and sweet tonight. But if anything comes up that you have questions on, feel free to drop it into the Q&A. At the end of the webinar, I'll go ahead and answer any questions that are there, do my best to answer them. But without any further ado, we're going to kick off the webinar, DOJ Stark Law Crackdown, right? 3 key developments you must know. So before we launch into it, quick little overview. Of our firm. We really focus in these 4 primary areas. The Anderson firm, we're based out of Jersey City. We've got offices in New Jersey, a couple of different locations, and then we actually handle deals and represent clients all over the country. So we represent physicians, facilities, practices, you name it, both in the tri-state area and in any state that you might be located. But if you have questions in some of these other industries, feel free to reach out at the end of the webinar or contact me directly. My contact info will be at the end of this, and I'm happy to chat about it. All right, so this is the 3rd webinar that we've put on here at the Anderson firm. Last month's was actually about selling your practice. Really interesting information, insightful about how to maximize the value of your practice. If that's something that you are interested in, let me know. I'm happy to send you a link for the video and some of the materials on it, and also just chat about it because it's there's a lot of information there. Today, though, we are focusing on some updates and amendments that were made to the Stark Law, which we'll get into that if you're not super familiar with it. Although if you're in the healthcare space, I'm sure you've at least heard of this law. We're going to give you a little refresher on the Stark Law and some of the other fraud and abuse laws that govern relationships for physicians and healthcare providers that you'll need to know about. We'll go over these amendments, some enforcement actions over the last year or two that have indicated a shift in policy at the DOJ. And then as well as a proposed amendment to the Stark Law that is making its way through the legislation right now. So without further ado, the enforcement triumvirate, all right? There are 3 laws at the federal level that every healthcare provider and physician should be aware of. And those 3 laws are the Stark Law, the Anti-Kickback Statute, and the False Claims Act. These 3 represent the backbone of almost all fraud and abuse enforcement actions and litigation that takes place in the healthcare space. All right, so what are these 3? Quick little overview here. Stark Law, we're going to get into more detail, but at a high level, the Stark Law prohibits physicians from referring patients for designated health services payable by Medicare or Medicaid to entities that they have a financial relationship with. Okay? Designated health services can cover a lot of different topics. We'll get into that list later. The focus here is trying to prevent conflicts of interest where physicians could benefit from directing the flow of patient care, right? Sending out referrals. These are civil penalties that are involved here. Repayment of claims, fines, and potentially exclusion from participating in Medicare and Medicaid. The next law, the Anti-Kickback Statute, or AKS, prohibits offering, paying, soliciting, or receiving remuneration to induce or reward referrals. Okay. It's basically designed to prevent and then penalize people who violate this law, sending referrals in exchange for anything of value. Could be money, could be gifts, could be favorable business terms, right? It's a pretty broad scope, but this law carries a much graver penalty. There's actually criminal penalties involved here. So violations could end up with people serving jail time, in addition to the violations, or excuse me, in addition to the civil fines and penalties that you may have to pay. The last element of this is the False Claims Act, and really violations of the first two, Stark Law and the Anti-Kickback Statute, feed into the False Claims Act. And the False Claims Act, broadly speaking, says that no one should knowingly submit or cause submission of false or fraudulent claims for payment to the federal government, right? So that's Medicare, Medicaid, federal workers' comp, other federal healthcare programs. And if you violate the False Claims Act, which, if you violated the AKS, you almost certainly will be found to violate the False Claims Act, then the government and potential private parties could exact treble damages. That's 3 times the amount of damages from the false claims, and other penalties, including potential whistleblower rewards. So these are super high level. These are very complicated statutes. Even the Stark Law, which we're going to deal with a little bit more detail in, is deserving of longer conversations, deeper analysis. But they are laws that if you accept federal dollars for healthcare services, you need to know how to be in compliance with these. All right. The next here, we're going to talk about the Stark Law specifically, right? And what the Stark Law prohibits, here's the language direct from the statute. So, you guys will get a copy of this, but it states that a physician or an immediate family member of that physician has a financial relationship with an entity. The physician may not make a referral to that entity for the furnishing of designated health services, DHS, and the entity itself may not present or cause to be presented a claim under this subchapter to a third-party payer, right, or other entity for those services. That's what triggers the False Claims Act liability, by the way. Okay. Financial relationships take one of 2 forms. They are either ownership in the entity, right? Some sort of ownership or investment entity, interest, or some sort of compensation arrangement. Okay. Real quick, for anyone who is curious about what DHS is, a quick little list of that is things like clinical lab services, PT services, occupational therapy services, speech and language pathology, radiology, radiation therapy, DME, prosthetics, home health services, prescription drugs, outpatient prescription drugs, and then any inpatient and outpatient hospital services. Again, if you are involved in any of these services, it's worth a conversation to talk about broader compliance. That's not really the focus of this webinar. Tonight, we really just want to focus on some of these updates that took effect and some of the trends that we're seeing. All right. Stark Law exceptions. Like I said, the prohibition is on ownership interest and compensation arrangements, but from these broader prohibitions, there are exceptions. The ownership exception is probably the easiest to understand. We're not going to focus on it. It deals with ownership in publicly traded companies or funds, things like that. Not super complex, but obviously very important to understand. But the primary driver of violations under the Stark Law is in compensation arrangements. Okay, whether they're direct or indirect, this is what trips people up. This is what triggers liability, and this is what results in action by the Department of Justice or potential whistleblower actions. All right. What are these exceptions? I've listed the 16 that are enumerated here. These are the ones identified either in the law, the statute itself, or in regulations that have been adopted by CMS. The important thing to understand here is that there's really three that I see most commonly creating concern and potential risk, and that is in personal service arrangements, fair market value compensation structures, and the rental of office space or equipment. So we're going to focus on those, and that's also where the amendments to the Stark Law really are really impacting. The most important thing to understand is that within all these exceptions, there is buried an expectation and a requirement that compensation arrangements are comply with fair market value, right? So if you're getting paid for services, you're getting paid the fair market value of those services. If you are paying for physician recruitment, right, you're doing the fair market value for those services or goods. You have some sort of physician incentive plan, right? Again, fair market value is implied, or excuse me, it's more than implied, it's required in all of these exceptions. But the 2021 amendments that CMS adopted specifically changed the definition of fair market value, generally speaking, and then in the rental of office space and in the rental of equipment. So we're gonna dive into that next. All right, key developments. All right, fair market value. This is without a doubt the source of much confusion among physicians and among healthcare entities. Understanding what fair market value is, it is critical that you get it right to survive scrutiny under Stark Law. So these changes that were adopted are going to be important for you to understand. So with the adoption of this rule, the Department of Justice and CMS are really decoupling Stark Law from the anti-kickback statute. Historically, there had been references within both of them, specifically in the Stark Law, that says that to get the safe harbor of some of these exceptions, you need to also comply with the anti-kickback statute. Well, that created confusion because the anti-kickback statute has an additional element to prove liability under that, and that's something called scienter or scienter, and that is intent, right? You have to have the intent to violate the law, the intent to commit the act that would violate the law. Stark Law doesn't have that. It's something called strict liability, and basically that means that the law is here. If you do anything that violates it, whether you intended to or not, you will have liability. That's also why there's only civil penalties associated with Stark Law rather than criminal offenses, right? Which the anti-kickback statute has. All right, so how does the decoupling work? What they've done is they've changed the definition of fair market value as it's generally applied in all of these exceptions. So under the final regulation, fair market value means the value in an arm's length transaction, that means between unrelated parties, that is consistent with the general market value of the subject transaction. So the value between two unrelated parties, what they would ascribe to that, and it is consistent with what that specific transaction would get in the marketplace among other parties, right? If you're to repeat this transaction with unrelated parties, right, a different scenario, you'd arrive at a similar value. Okay. The final rule also includes an amended definition of general market value, which is focused on considering only the economics of the subject transaction and gives no consideration of other business the parties may have with one another. What does that mean? So a lot of times what happens is between a physician or physician group and one of these entities, there could be a long list of different types of arrangements or relationships. You might be leasing from the entity or subleasing from the entity. You may be sending patients for PT at the entity. You may also be buying goods from an affiliate of the entity, right? Maybe DME, other supplies, right? You may be providing supervision over other physicians employed at the entity, right? Even though you're an outside practice. So there's lots of relationships that can crop up here. And what it's saying is general market value needs to be understood in a vacuum that cannot take into consideration those other business relationships, right? Arguably, there has been an argument that's been made from time to time that, oh, well, we can pay more in this transaction because by creating the proximity to the physician group, we've actually increased the value of this transaction. You're not allowed to do that, right, anymore. And it's very explicit in the new definition of fair market value. The other area where the definition has been changed is with the equipment rental, right? So CMS has defined fair market value in that context to mean, this is going to sound a little repetitive, the value in an arm's length transaction of rental property for general commercial purposes. So not taking into account its intended use, consistent with the general market value of the subject transaction. So if you're renting office space, or excuse me, you're renting equipment, maybe it's diagnostic equipment, maybe it's other durable, or excuse me, capital equipment. Even if it's a copier, right? A copy machine. If you're renting this, it needs to be viewed, the value needs to be viewed absent what the actual intended use is, and needs to reflect what that transaction would get outside of this specific relationship, right? So if you're renting a copy machine, what does a copy machine normally rent for in the public market, right? The terms would need to reflect that value. That is what is considered general market value. Okay? Office space rental is similar, right? We start off almost identical, saying that it's the value, or excuse me, fair market value in an office space rental is an arm's length transaction of rental property for general commercial purposes, not taking into account its intended use, without adjustment to reflect the additional value the prospective lessee or lessor, right, tenant or landlord, would attribute to the proximity or convenience to the lessor, where the lessor is a potential source of patient referrals to the lessee. Okay. So again, general commercial use or purposes means if someone is renting an office space, medical office space, it would be the value generally for a medical office space. The fact that they are performing spine surgery in there doesn't matter. Or the fact that maybe they're engaged in reproductive medicine and are cash, are mostly receiving cash payments from patients, right? That is irrelevant to establishing the fair market value of the rent that can be charged when leasing or subleasing a space. One other element that was added here, it's not really related to commercial, or excuse me, the fair market value, but I think it is important to understand is the notion of exclusive use when it's applied to equipment rental and space rental. Historically, exclusive use has basically been a bit ambiguous. what does that mean? Right? Does your tenant need to have use of the space, or your subtenant need to have use of the space to the exclusion of all other parties? Is it just the landlord, right? What does that mean? And the CMS has clarified this. Exclusive use requirement only requires that the lessor, right, or any other person or entity related to the lessor is excluded from using the space or equipment. So conceivably, you could have an office space that multiple sublessees are using during a given day, but as long as and that would be okay under this new interpretation, at least that's our understanding, so long as the lessor does not have the right to use that space as well, right? So it could be a communal space for sublessees, but the lessor cannot have access to it or use it during that time. That's what creates the exclusive use requirement. So we're just going to touch on those in terms of the amendments in the Stark Law that were adopted in 2021 and 2022. These updates were extensive, right? They cover a wide range of the exceptions. They talk about indirect compensation arrangements. They talk about what is considered commercially reasonable. They talk about how to interpret value or volume arrangements in compensation arrangements, or excuse me, value and volume factors in compensation arrangements. So it's worth a conversation if you handle any of these or in any of these types of arrangements, compensation arrangements with an entity, or you are an entity and you have these arrangements with a physician. It's worth a detailed examination of these contracts to understand if you're in compliance with them. All right, now the fun stuff. We talked about the shift that these amendments represent, right? Decoupling the Stark Law from the anti-kickback statute. And the reason why they did that is it now becomes easier for the DOJ to bring an enforcement action strictly under Stark. So generally, when they would bring these claims, they would wrap up violations of AKS, Stark Law, and the False Claims Act all into the same action. And it got a little bit confusing and at times challenging for the DOJ to prove violations because of that interdependence I talked about. Well, now, by separating them, the initial charge may still allege anti-kickback statute violations and False Claims Act violations, but they're able to extract settlements strictly from the Stark Law violations. So here are some examples of this. Just in this year, we saw a $1.8 million settlement with United Neurology. That was strictly on the Stark Law violations. Kind of run through this, but right, New York Presbyterian Hospital had a $17.3 million settlement, again, along the lines of Stark Law violations, even though the original complaint alleged violations of Stark Law, AKS, and FCA. One thing to note here, this settlement most likely would have been significantly larger if it had been discovered by DOJ, but instead what happened is the hospital self-reported. They had these contracts with this other entity, Park Slope Medicine, that they were concerned may violate one or all of those laws, and so they self-reported. As a result, they obviously did not escape liability, but they did escape some of the more extreme consequences, which would be the additional fines and potentially the exclusion from participation with the Medicare and Medicaid programs. Again, 2023, we've got these 4 different actions, some of them quite large, $345 million settlement in the Community Health Network complaint. The key here is that this represents an uptick in enforcement actions the DOJ is bringing, and an uptick in the settlements that they're able to obtain, I believe, directly as a result of these changes adopted in 2021, the amendments to the Stark Law. So again, There may not be criminal penalties associated with Stark law violations, but if they are discovered, right, and DOJ brings an action against a practice or an entity, both, you can bet that there is going to be a significant penalty, a significant fine, and you may have to enter into these corporate integrity agreements, which is essentially like having a a microscope on every action your entity takes or your practice takes for the next 5 years, right? Having a representative of the OIG scrutinizing every single detail. It's very unpleasant to have to do. The alternative obviously is probably losing eligibility. But again, serious consequences, even though there's no criminal consequences. So compensation arrangements, like I said, are one of the primary sources for these violations, and direct or indirect arrangements all would fall under this prohibition, unless you have an exception. And direct is an easy one. That's where the entity is paying the physician directly, a salary, some sort of other compensation arrangement, but it's directly from the entity to the physician or the physician to the entity. The indirect is something like having the sublease, right? Maybe you're leasing a space from the entity, or excuse me, from an affiliate of the entity that's wholly owned by the entity, but the contract itself is not between the physician or the physician's practice and the entity, right? There's intermediate steps there, or maybe there's a chain of contracts that all are unbroken between the physician and the entity, and those are indirect compensation arrangements that all require this compliance with the Stark law, and all are ripe territory for enforcement actions. Again, it is an extraordinarily complicated area of healthcare law that can carry very dramatic consequences for noncompliance. So any sort of transaction, any sort of contract needs to be viewed through this lens, needs to comply with these exceptions. All right. Last update. This one is, I thought, just an interesting update that is actually a benefit to physicians and providers, but there's a law that is currently in the committee, or excuse me, in a House committee that is hoping to reinstate permanently the waiver that CMS had during COVID that would allow drugs provided under Medicare to be distributed to patients without them physically having to come in and pick them up. Right. So right now, that waiver has expired. It actually expired last year, May 11th, 2023. So if physicians are currently doing this, they face a Stark law violation. So if they continue to deliver drugs to their patients or allow someone other than a patient to pick up the drugs, that would technically be a violation right now. So this waiver, they're looking to make permanent to actually allow that going forward. That's positive news. We'll keep track of that as it moves through committee into the floor. So far, it's receiving bipartisan support, so there's hope for it. But being an election year, there's not a whole lot that's going to get done over the next 6 months. So stay tuned to that. All right, everyone. That concludes our short little presentation. Again, we just have a tiny little sliver on the Stark law. It is a massive regulatory schema that has serious consequences, needs to be complied with, is very difficult to understand, right, for most providers and facilities that are reading on their own, but its compliance is essential. And some of these changes reflect a position of the US government to be a bit more aggressive on cracking down on fraud and abuse than what they have been previously, which already I would argue has been a very aggressive stance towards healthcare providers and entities. Here's a little bit about me, contact information. You know, I've been in the healthcare space for about a decade now, representing physicians, practices, facilities, ASCs, MSOs, you name it, sort of running the gambit on different activities. Excuse me, different physician groups and things like that. So if you have any questions, feel free to reach out. I see that someone's raised a hand. I'm not really able to do anything about that at the moment. If you have a question, go ahead and drop it in the Q&A. And I'll do my best to answer it. But that is concluding this presentation. So I appreciate everyone for taking a few minutes out of their day to tune in. Hopefully this was interesting, useful. It's going to be available for access. Yep. Okay, I got you. Yes, I'm going to send a follow-up to everyone that's going to include the presentation materials. They'll have my contact information, and most likely they'll have a link to the video once it gets posted on YouTube, just in case you wanted to revisit it for any reason or share it with anyone. But again, thanks everyone. Have a great day, great evening, and I look forward to speaking to you later.